Ghanatube so snowy masai swatena say Elsia for Dimechi na yenkotie ensemba kumienu bi a ekoso ewo o manga ni muna say ba na de eka hono me de atwaso amamo Dimechi.
Thank you for choosing us this afternoon. First, Member of Parliament for Tāfo Vincent Eko Assefuah has sued Attorney General Dr. Dominic Ayine at the Supreme Court over petitions to remove Chief Justice. You recall that on Tuesday, President John Mahama began consultation with the Council of State following 3 separate petitions seeking the removal of the Chief Justice. The petitions submitted by various individuals have been forwarded to the Council of State as required by Article 146 of the 1992 Constitution. Now, in this suit, Eko Assefuah is asking for the following, which I'll be showing you on your screens shortly. Petition to remove Chief Justice, and it says that nature of relief sought as follow. 1. A declaration that upon a true and proper interpretation of Articles 146 Clause 1, 2, 4, 6, and 7, and 23, and also 57 Clause 3 and 296 of the 1992 Constitution, the President is mandated to notify the Chief Justice about a petition for the removal of the Chief Justice and obtain his or her comments and responses to the content of such petition before referring the petition to the Council of State or commencing the consultation. It also continues to say that a declaration that upon a true and proper interpretation of Articles 146 Clause 1, 2, 4, 6, and 7, and Article 23 and 296 of the 1992 Constitution, a failure by the President to notify the Chief Justice and obtain his or her comments and responses to a petition for the removal of the Chief Justice before triggering the consultation process with the Council of State will constitute a violation of Article 146 Clause 6, as well as the constitutional protection of the security of tenure of the Chief Justice, who is a Justice of the Superior Court of Judicature, stipulated in Article 146(1) of the Constitution. Also, third relief that he's seeking, a declaration that upon a true and proper interpretation of Articles 146, 1, 2, 4, 6, and 7, 23, Article 23, Clause 57, 3, and 296 again of the 1992 Constitution, a failure by the President to notify the Chief Justice and obtain his or her comments and responses to a petition for the removal of the Chief Justice before triggering the consultation process with the Council of State amounts to an unjustified interference with the independence of the judiciary enshrined in Articles 127, 1, and 2 of the Constitution. Well, let's speak to former Deputy Attorney General �aupreme on this. Thank you for joining us this afternoon. You may have seen the reliefs that Eko Assefuah, Member of Parliament for Tāfo, is seeking. Are these grounded in law?
Well, thank you very much, my sister. Yes, I have seen the writ filed by Eko Assefuah, and I've also seen the relief that he's seeking from the Supreme Court. And it's so basic that if you have an issue relating to an unconstitutional conduct on the part of any public officer, including the President, or you may want any interpretation of the Constitution, then per our constitutional architecture, you have the right to go to the Supreme Court to ask for various relief. And so looking at the relief that the gentleman is seeking, it's only in a way upholding its rights under the Constitution to ensure that the right things are done. That's from his point of view.
Well, are there any ambiguities so far in the processes that the President has been following so far, especially following him receiving the petitions? I'm certain that you may have heard or seen that he has consulted with the Council of State so far. What really is the ambiguity for the gentleman to want to exercise his right as a citizen at the Supreme Court?
If you read the writ that the gentleman has filed, he's not talking about ambiguity. He's talking about an act having been done by the President, and he thinks that that act is an unconstitutional act. So he's not going to ask for any ambiguity to be cleared. I mean, the issue that he has raised in this writ is whether the President upon receipt of the petition, will have to notify the Chief Justice before he consults the Council of State for a prima facie case to be made. That is the crux of the whole writ, as I can read from what I've also seen. And so that question needs to be answered by the Supreme Court. And I think it's not something that we should just gloss over. It's so fundamental. If that's the case, then the declaration will be made to that effect. If that's not the case, then the Supreme Court may want to declare the other way around. But that's the crux of the case.
Considering the process is supposed to be done in camera, whatever part the process has been prescribed in the Constitution, would it be that the Chief Justice would have to be announcing to us whether or not he's been consulted or he's been allowed to see these allegations leveled against him or the petition at all? Is it that the gentleman in question is probably aware that he or she may know, or he thinks generally there's some sort of violation here?
Yes, you may not know the information the gentleman has. Now that he has filed the writ, the response from the AG will indicate whether that process was gone through or whether the AG disagrees with him, that the CJ will have to notify. So we may have to wait for the response from the AG also.
What's your take on the whole architecture of the judiciary, especially in the interference, which has been some of the concerns that many stakeholders have said? What's the outlook? What's the optics for you?
Yes, if you look at Article 127 of our Constitution, it guarantees the independence of the judiciary. And history will tell us that since independence to date, if my memory serves me right, it was only during the time of Mahama that the CJ was removed from office. Let's fast forward to 1992 Constitution. From 1992 to date, no CJ has been removed from office. Why is it so? It's so because we may want to protect the independence of the judiciary. Unless, of course, you have a hardcore evidence against the CJ bordering on incompetence, bordering on impropriety, etc. But any flimsy allegations will not fly because we need to make sure that we protect the independence of the judiciary. I don't know the content of the petition, so I'm making this assertion based on the fact that if you are a petitioner and you may want the CJ to be removed, then you have a very solid base to do it. Because we cannot toy with our democracy by constant removal of our Chief Justice. If we go along that direction, then we are doomed as a nation.
Will it be the frequency of it, and I ask because of the role of law anyway and public accountability? Will it matter at all in optics such as this one?
As I said, I'm not prejudging what the Council of State will be saying or will determine. If there's hardcore evidence and due process is followed, I mean, that's the beauty of rule of law.
Okay.
But I'm only making the point that frivolous, flimsy, and watery allegations will have to be treated carefully in order not to interfere with the independence of the judiciary.
Right. Please stay with me just a moment because President John Dramani Mahama is calling for the establishment of specialized fast-track courts to deal with cases of financial misappropriation in government. Speaking after the Ghana Association paid a courtesy call on him, President Mahama expressed concerns over the misuse of public funds. He believes a specialized court will support the constitutional procedure to uphold individuals accountable in a timely manner. Please tell me, thank you for still staying with me, but tell me, we've had such a system before. I'm not too sure why we don't have it, but is this illegally in our legal framework currently? Can it sit, or it will require a certain form of amendment?
All right, yeah, if you look at our court structure, especially if you go to the High Court in Accra, we now have the specialized court. And what does it make a court, or what does it entail to say a court is a fast-track high court? It's about improving the system there. For instance, if you want to automate it, you automate it properly. So that we don't have a system where currently, as we have it, you go to court, whatever that you say as a lawyer, the lady simply behind the computer has to type it out for you to see. But you can have a system where, as you even argue, automatically it's transcribed. I mean, that's an improvement on the system. So we may choose to name court as fast track high court, but if we do not have the right ingredients there, then there may be normal high court. But my concern is not even about naming it. It's about how efficient that court system will be. As we have it now, we have laws relating to how cases are supposed to be tried in our courts. And you all know, my sister, that some cases that the previous administration started, of which I was a part, took over 6, 7, 5, 6 years. And we're not able to complete those cases. Why? Because those accused persons, our laws have the right to challenge every order that a judge makes in case that they are facing trials. And so on, to be able to take away that bit out of our legal system, where we want to say that you can appeal against an interlocutory order only after the state has closed its case, then we can, I'm telling you, then we can have the fast track high court, but still people will go ahead and vindicate their rights by challenging orders of the court. Before we left office, there was a proposal by the AG's office to amend our Criminal Procedure Act. The bill was submitted to Parliament, the Committee on Legislation and Constitutional Affairs. They went through it, but we could not finish it. If you are not going to amend those parts of our laws, you are going to rely on what we have now, then it matters not the name that we give to a court. We are going to fall in the same pit.
So for this particular fast track high court, if I understand you, is it needed or not at all? Can we just work with the legal framework that we have already, or by all means and at all costs we should have it?
Already we have the court. If it's about naming, then I think it's not needed. But if it's about improving the infrastructure in the court, then it's something that we all will support. It's not about the name. It's about improving the infrastructure. You can even improve it without even changing the name to make it fast track court or whatever, because it's about the court dispensing justice. And everybody wants this case to be fast tracked so that he can know his fate. But this system that we have now, where judges have to even write, those in Accra even better, go to the region, where judges have to sit and they have to write everything. So we need to improve that system. If you are ready to commit resources to improve on all the courts in Ghana, the courts in Ghana will work efficiently.
Well, thank you so much for talking to us. But
Madam, as I said, we did make and Sema Elcoso, answer a message almost on me. I was a Ghanatube. So, who makes me age our comments, Eddie Amayan, na Ța Kai Eddie Amor fair. One subscribe and subscribe. Now found a mere notification bell no so. Said I be in 72 now we know in temper. So, snowy near everything for my crown.